Council, and welcome to our June 3, 2020 oral argument docket by video conference, which we are live streaming in an effort to maintain our duty to the public to hold our court proceedings in the view of the public. And we are thankful that you have agreed to participate in this matter. We will conduct the hearing in the same fashion as if we were in the courtroom, and each side will have 15 minutes. The appellant may reserve up to 5 of your 15 minutes for rebuttal. Are there any announcements? Hearing none, Mr. Hibner, call the case, please.
James Justice versus Paul Gaiter et al.
Good morning, Your Honors. Drew Justice for the plaintiff appellant James Justice. I'll reserve 5 minutes.
Thank you, Mr. Justice.
May it please the court, the ultimate question in this case is whether to create a jury question on comparative fault, it is enough for a defendant merely to say, I think the blame should be shared. In this trial, despite the defendants making that statement, no rational juror could have found that the plaintiff was at fault. And for 3 basic reasons. 1, the defendant admitted that the plaintiff was faultless. 2, the clear evidence showed that the plaintiff had the right of way. And 3, the physical evidence made it impossible or palpably improbable for anything to have happened other than the plaintiff being hit on the side of his car. 1, the defendant's admissions. As I've said, the only evidence in this case for any comparative fault, if we can even call it evidence, was the defendant's statement that he thought the blame should be shared. The reason why that does not create a jury question on comparative fault is because the defendant clarified twice that what he meant by the blame should be shared was that neither person was at fault. And he essentially stated that the plaintiff himself was not at fault. On volume 4, pages 12 and 13 of the transcript, the defendant said in the same breath, he said, accidents just happen. He said the plaintiff was reasonable. He said that his own visibility or visibility in general, I believe he said, was limited. And then that's the point when he said any blame should be shared. On pages 14 and 15, his deposition testimony was read into the record, specifically where he said that he himself was not negligent. He said, we saw each other, but it was too late. And then on pages 18 and 19, he talks about the plaintiff's, essentially the plaintiff's good driving. He said the plaintiff was not going fast, and that when the plaintiff, that as soon as he saw the plaintiff, he slammed on his brakes, and the plaintiff's reaction was to move to the right to avoid him. So in essence, there was just no testimony that the plaintiff did anything wrong. One important thing to keep in mind when deciding this issue is that it's actually the defendant's burden to prove comparative fault. Comparative fault is an affirmative defense, and therefore it's an affirmative defense under Rule 8.03. And as such, it's the defendant's burden to prove it. Ultimately, in this trial, there was no testimony that I could find, either by the defendant or the plaintiff, about the plaintiff doing anything wrong. And in the defendant's appellee brief, the only thing he can even point to in terms of a breached duty, supposedly, was he just said the plaintiff had a duty to avoid the accident. And the reason why that's...
Let me ask you something. There's a picture, presumably of the plaintiff's car in the exhibits. I didn't see, back in the days before technology, we'd have people to draw up an accident map and show us what happened. And I didn't see one of those there. Can you briefly explain how the accident happened?
The plaintiff was driving on a road in between 2 parking lots, and I think there's some dispute on whether it's a private road or a public road, but it was effectively a road in between 2 parking lots. The plaintiff was coming from his left, out of the parking lot on his left. There was heavy traffic.
Whoa. And don't use pronouns, okay?
The defendant was coming from the plaintiff's left, and then the physical evidence shows that the plaintiff's driver's side door was dented in. There was a little bit of scraping damage further back on the plaintiff's car as well. And so there was damage shown in one of the other exhibits showing that the defendant had damage along the front of his car.
So the defendant was coming out of a parking lot?
Correct. And then one way or another, the plaintiff's driver's side door got damaged. And the defendant says that's because the plaintiff somehow hit him. And I'm saying that that's impossible, that you can't hit someone with your own driver's side door who is standing still. So basically the fact that basically brings us to the second reason why there can't be any comparative fault. Simply put, the plaintiff had the right of way in this scenario. And so that just reinforces, again, his lack of fault. If he's on the road and the defendant is pulling out of a parking lot, then he has the right of way. And what that means, if he has the right of way,
There you go with the he's again.
I'm sorry. That means the plaintiff has the right of way.
Okay.
And so if the plaintiff has the right of way, then by default, if there's a collision, that tends to mean he's faultless. By default.
Well, not necessarily, because the plaintiff may still have an opportunity to avoid the collision and things like that too.
Right. And that's what I mean by default, like just.
And that's why.
That's what I mean by just saying by default he would be without fault. In some unusual circumstances, or if the defendant, I mean, that's not saying the defendant can't still potentially establish that he's at fault, but you would tend to assume that if he has the right of way.
Well, the plaintiff also has a duty, is what I'm saying.
That's right. But ultimately what it boils down to in reference to Your Honor's concern is just there wasn't any testimony about the plaintiff having an opportunity to avoid the collision, about him seeing it in time to stop or anything like that. There was the opposite. The defendant specifically said we saw each other and there wasn't time to react. So there's that. There's the right of way, and then finally just the physical facts of the case. We've already sort of touched on that, but if a party testifies to something that is physically impossible or palpably improbable, then the court is allowed to disregard that testimony. In this case, the defendant testified essentially to a contradiction. He said he admitted on page 13 that the defendant admitted on page 13 that the plaintiff's driver's side door was involved in the accident. On page 14, however, he said that the plaintiff did not hit him with his driver's side door. And then if we go back to page 7 of the transcript on volume 4, he said that the defendant said that the defendant was still and the plaintiff hit him. So in essence, he's saying that the plaintiff both did and did not hit him with the plaintiff's driver's side door. So that's a contradiction right off the bat. But even if we get beyond the law of non-contradiction, there's the more basic point that it's just physically impossible for a car to drive sideways unless there's some kind of swerving, which the defendant said there wasn't. Cars drive straight, they don't drive sideways. And so if your driver's side door is dented in, then you must not have hit a still fixed object.
Is there any testimony that the plaintiff was attempting to turn left?
No, there was not, Your Honor, and there was actually the opposite. The defendant testified, it's on pages 18 and 19 of volume 4. He said that when he saw when the plaintiff saw the defendant said that the plaintiff tried to move to the right. So there was no testimony that he was ever even starting to turn left. And there was actually testimony that he did at one point try to avoid the collision by turning right. And so I just don't see how his driver's side door could have been dented in if the defendant was truly still, as the defendant claimed. So ultimately, due to the defendant's admissions, his general failure to specify any way that the plaintiff was at fault, the evidence of the plaintiff's right-of-way, and the general physical facts rule, I would just say there was no rational way for any juror to find comparative fault in this case. And I'll take the rest of my time.
Mr. Justice, I have one question. I understand the jury did not award any damages. Was that an affirmative decision by the jury, or did they simply not get to that phase because of the determination of fault?
They didn't get to that phase because of the jury instructions told them not to get to that phase. And I think they even had a question about that at one point. It may not be in the record, but they asked whether they should still get to damages, and the judge told them no.
Okay, very good. Thank you. All right, Mr. Lee.
Good morning, Your Honors. My name is Jason Lee. I represent Mid-Century Insurance Company. The Tennessee Court of Appeals has said that challenging a jury's allocation of fault is the legal equivalent of a Hail Mary pass, and that's what's going on here. In the Duran versus Hyundai decision, the Tennessee Court of Appeals went on to state that the comparison and allocation of fault is for the jury. The appellate courts will not second guess the jury's allocation of fault is supported by any material evidence. But that's what Mr. Justice, the appellant, is trying to do in this case. This case is pretty straightforward from a factual perspective, and I'll try to explain the accident. The defendant, Mr. Gator, was carefully pulling across busy traffic. This is between two parking lots in Williamson County, and there's two roads that are going past each other. Another driver stopped to allow him to pull out. He was turning across traffic, and as he inched out, he came and proceeded, and then Mr. Justice's vehicle was coming this other direction as he's inching out, and he pulls out, and Mr. Gator's testimony is he was stopped, and the vehicle of Mr. Justice hit him, the plaintiff hit him, and that's where the collision occurred. And so the plaintiff, on the other hand, testified that he was stopped, and that and what he said was he was T-boned, and that the defendant's vehicle was barreling down on me. That's what he said at trial. So the only real evidence, so both plaintiff and defendant say they were stopped and the other struck them. So the only neutral evidence we have in this case are the photographs. And those were submitted to the jury, the photographs of the plaintiff's vehicle, 2 to 4, and then the defendant's vehicle, exhibit number 23.
One of them's upside down.
Yeah, I saw that. So the photographs do not support the claims of the plaintiff, Mr. Justice. And the issue is this: the damage on defendant Mr. Gator's vehicle was primarily on the front bumper, primarily on the right side of the front bumper. The damage also shows scrape marks on the front bumper, indicating that the other vehicle was moving, not his. The damage on plaintiff's vehicle was down the side of his vehicle, not just the door, but also on the rear, which indicated he had to have been moving. And the explanation about the door is very easy. When he's coming into this accident and he strikes him, he's going to turn to the right to avoid bearing the brunt of the impact, and that's going to cause the scraping down the side of the vehicle. The photographic evidence was neutral. That's the only neutral piece of evidence we have when we have plaintiff and defendant differing on what happened. But the damage is clear. It shows scrape marks on both vehicles, indicating that the plaintiff's vehicle was moving, not the defendant's vehicle. And remember, it's a material evidence standard. So the only question is there sufficient material evidence to support the jury verdict or not? As this court knows, the testimony of live witnesses and their credibility is incredibly important to the fact finder to decide and assess the credibility of the witnesses. So even today, as we look at the trial transcript, we can't see the hand motion, just like I'm doing now, that you can see my hand motions, which the jury saw from both the plaintiff and the defendant describing what happened with the vehicle. And I notice I'm talking with my hands. I see myself, and it's different than when I don't see myself. But
it's a pretty good substitute for a handwritten map, so that's fine.
So the jury and the judge saw all of that and the obviously neutral photographs. And the plaintiff's credibility was hurt based on other things he testified about. For instance, he actually testified at trial, and if you can see the pictures, the damage is incredibly minimal. The defendant said he never even fixed his vehicle. He still drove it to this day. But the plaintiff testified. He was asked, what was he thinking when he saw the defendant's vehicle coming towards him? And he said, I thought I was going to die. That's what he said. Now this is a parking lot accident. And so these are all things that go into the jury's assessment and evaluation of the truthfulness of the plaintiff and the defendant. And they just did not believe the plaintiff. It's that simple. So ultimately, what did the jury do? The jury found a 60-40 split on comparative fault. Obviously, even if it was a 50-50 split, the plaintiff would get nothing. So either way, they would have gotten nothing. And there's just no basis to disturb the jury's finding under this situation. The Wilson case, the Tennessee Supreme Court case, says explicitly that it is a finding of fact by the jury on comparative fault. So this isn't something that should be overruled. And then we look at the material evidence standard in the Bourne versus Celadon case, which clearly outlines in 2017 what is material evidence. The court said evidence material to the question in controversy, which must necessarily enter into the consideration of the controversy, and by itself or in connection with other evidence be determinative of the case. But we have the photographs and we have the testimony of the defendant, which was obviously accepted. That's sufficient material evidence. And
what was the proof of damages or injuries that the plaintiff had sustained in another accident? There was an issue about that.
Yes, there was another accident that he had, and that was discussed briefly, and obviously the jury heard about it. But that all went to the damages issue, which obviously the jury didn't even get to. But there was another accident, and so that was a question as well at the trial. But ultimately, the jury didn't get to that issue. The Bourne case is really important because what it says about material evidence, they said, it matters not a whit where the weight or preponderance of the evidence lies under the material evidence review. It is simply a search of the record to ascertain if material evidence is present to support the verdict. And the trial judge did a really good job in this case post-trial. You know, he was there, he saw the evidence, the live testimony of witnesses, and he specifically said exactly what I've said, that the photographic evidence actually weighs in favor of the defendant's argument about the damages because of the scrapes down the side of the vehicle. This wasn't a T-bone accident. The evidence of the photographs helped support that. So I will address the testimony of Mr. Gator. Mr. Gator did say at one point that any blame should be shared. That doesn't necessarily say equally. It was a statement that he made. And I think, frankly, the jury found him to be candid. He was saying, you know, and he said accidents happen. But if you look, he never said that the plaintiff was not at fault. That's not in the record. What he did say was any blame should be shared and that accidents happen. And I think he was just being candid with the jury. He also said, I think I'm just as responsible as the other driver. Accidents happen on page 12. That's reasonable testimony. I think that's why the jury found him to be believable. The other question that was raised is about the right of way. Well, the right of way, first of all, this is a private area, and I agree that was never really definitively decided, but this is a private property situation. So the rules of the road, do they apply or not? That really wasn't expanded on. Regardless, right of way is just something that goes into the hopper for the jury to decide on comparative fault. The law is clear on that. Just because someone has a right of the way does not mean that they automatically win. Otherwise, every case could be decided with, well, who had the right of way? The plaintiff still had a responsibility to avoid the accident and to take reasonable steps to avoid the accident. That is the burden of proof on comparative fault. Counsel's right, was on the defendant. Well, the defendant had his testimony and he had the photographic evidence. And those things show that the plaintiff should have avoided this accident. And they obviously believed the defendant's version of the facts, that the defendant was stopped and the plaintiff was the one moving and he wasn't paying attention. And that's all you need. We're a comparative fault state. We're not a comparative negligence state. And so the jury does that analysis and it's a factual determination, and that's what they decided. So ultimately, there's just no reason for the jury verdict to be disturbed in this case. The plaintiff was provided a full opportunity to have his case heard. All of the evidence, which was opposite testimony from the parties, and the photographic evidence was presented to the jury, and the court rejected the plaintiff's claim, 60% to 40% on comparative fault. Unless there's anything else, that's all I have. It's a pretty straightforward case, Your Honors.
All right, thank you, Mr. Lee. Mr. Justice.
I heard a lot in that argument about basically attacking the plaintiff's credibility. The problem with that defense is that our appeal isn't based on the plaintiff's credibility, or to the extent that it's based on the plaintiff's credibility at all. It's only just in conjunction with the physical facts rule, which is, as you've heard, my tertiary arguments.
Mr. Justice, how do we ignore the plaintiff's credibility when we review whether there is substantial material evidence to support the jury's verdict?
I guess what I'm just saying is, I would assume you shouldn't. I don't know. Can y'all hear me? It sounds like the connection may be breaking up. But
I hear you.
You should not. All right, you should not consider the plaintiff to be credible, because under the standard of review, you're not supposed to. You're supposed to assume at every point where credibility matters that the plaintiff is not credible. And you're supposed to assume to whatever extent you can in conjunction with the physical fact. So the credibility just has nothing to do with it under the standard of review. I'm not saying the plaintiff was lying, but I'm saying for the standard of review, you're basically supposed to assume that he was.
That the plaintiff.
So you heard. I'm just saying for the standard of review, that's you're supposed to assume that the plaintiff's evidence is not credible, and the defendant's evidence was credible. That's
you want us to believe that your client was not credible?
I don't want you to believe that, but you have to, under the standard of review, that's what you assume. That's what you, you can't win an appeal based on material evidence by just saying my client was believable. And so I'm not asking you for that. I'm just saying that you, the evidence that he was at fault, whether he's believable or not, whether the plaintiff was telling the truth or not, there was no evidence introduced that the plaintiff did anything wrong. The only two things that the defense counsel.
What about the photographic evidence and the bumper and the scrapes and the
photographs? The photographs at best, I still contend that under the physical facts, the photographic evidence is entirely consistent with what the plaintiff said, and it's entirely inconsistent with what the defendant said, because you can't hit someone with your own driver's side door. The person you hit or the vehicle you hit is sitting still. The plaintiff, I will just clarify that the plaintiff never said he was 100% sitting still. I think he said he was stopped or virtually stopped. So he left that open, whether he might have been moving a little bit right before the collision. But regardless, the physical facts would have to show that the defendant was moving at least somewhat. Otherwise, the plaintiff could not.
Excuse me, Mr. Justice.
I'm sorry.
Did the plaintiff testify that he thought he was going to die?
Yes, and he also testified that not only was his driver's side door dented in, but his driver's side window was shattered, and that's why there's no window in the picture.
All right, now.
Yes, he did testify to that. And again, just saying that he thinks he's going to die. I mean,
pardon me. And the jury saw the picture of the defendant's vehicle, exhibit number or 23, is that right?
Right. And I would submit that the most proper way to interpret those photos is exactly what the plaintiff did say, which is that he got rammed in his driver's side door, presumably with the defendant right front corner, and then the defendant basically turned and slid a little bit and then nicked the back of the
I'm looking at the picture of the
plaintiff's
front of the
driver's side as well. So that's where the scraping came from.
I'm looking at the front of the defendant's vehicle, okay, at a picture of that. And I don't see enough damage to consider that there was a T-bone accident or even a collision for that matter. I just don't see it from the picture itself. Am I missing something?
Well, I mean, I think it would be up for debate whether the defendant really had any work done.
Was there any proof he had work done or not?
I would just submit that's a little the damage. Well, I guess I would just submit that it's a little bit beside the point what impact he had, like the forcefulness of the impact, or whether the plaintiff really thought he was going to die or any of those.
This is evidence.
I'm sorry.
This is evidence that the jury had, right?
Right, but the thing to keep in mind is the jury found that the defendant was at fault for this collision, and we don't dispute that. The only thing we dispute is that there was no evidence that the plaintiff was at fault. And the defense counsel said in his argument that the plaintiff wasn't paying attention. There was no evidence, no testimony that the plaintiff wasn't paying attention.
Right.
There was no testimony from
Thank you,
the
Mr.
jury could
Justice.
infer it.
You're
All right,
cleaned
thank
up,
you.
Mr. Justice. Thank you for your argument. And Mr. Lee, thank you for your argument. And that concludes this case, Mr. Hebner.
This court is now in recess.
Thank you.